Good morning. Thank you very much for joining us for a very, very special nuts and bolts presentation on COVID-19, how to inoculate your real estate transactions. There are things that we are doing differently now from a risk management standpoint, whether you are the owner of a company and the broker designate or an agent. Today, we have two very special, very experienced individuals to share their thoughts. We have Alan Zhang, who most of you know as a past chair of ARIA, but he is also maybe as important, maybe really more important, the owner of the largest Asian-owned independent real estate company in California, possibly the United States. It's Presidential Real Estate. Alan still conducts his office meetings and handles the risk management for all of his hundreds of agents. With him, he will be in conversation with Neil Kalin, the Deputy General Counsel for the California Association of REALTORS. Neil has been experienced in the real estate side, helping real estate professionals manage their transactions in case to how to prevent themselves from getting into legal hot water, and some thoughts on how steps they could take to protect themselves otherwise. Neil is the author of a document that many of us in California, if not all of us, are using, the Coronavirus Addendum / Amendment, and the subsequent documents as well. So with that, let me turn the presentation over to Neil Kalin, who will do a presentation before Alan and he go into a fireside chat type conversation. Neil.
All right, let me get my right screen up. Give me just a moment, folks.
And as Neil's getting the screen up, I might also say that please have questions through the chat. They will be curated and present and delivered to Alan and Neil by staff. Thank you.
All right, great. Thank you very much. It's a pleasure to be joining you today. I wish I could take credit of being the author of all of the sole author of all of the forms that you see on your screen, but I have a lot of help at CAR, and I could not do it without my colleagues that I work with. So for the first half an hour, I'm going to go through some of these forms and some of the issues that we're seeing. So the very first form that CAR introduced is Form CVA, the Coronavirus Addendum or Amendment. It's actually been modified one time since we first introduced it. I think we are first in the nation to have something available for our members. And I see from various NAR servers and chat boxes that a lot of associations do similar things right now. After we came out with that form, we added something called the Notice of Unforeseen Coronavirus Circumstances. I'm going to talk about that next. Then we came out with two forms that really deal with listings and showings. So listing agreement addendum and what we call the PEAD form, the Property Entry Advisory and Declaration. And just came out with two brand new forms dealing with landlord-tenant issues. Came out with them yesterday, I believe, is when they went online at car.org, and they're going to be on zip form starting tomorrow morning. And the first one is really a letter. It's a notice to tenant of ability to pay. And the second one is basically a delay in repayment agreement. So that's the RPD form. So that's what I'm going to be talking about. And let me get right into it with you. I know we want to allow a lot of time for discussion and question and answers. So I'm going to move through them a little bit more quickly than I normally would, where I have a full hour to do the webinar just talking about the forms. Excuse me. So here's the first one. And the purpose of the Coronavirus Addendum or Amendment is to address issues that are coming up between buyers and sellers. There's a lot of uncertainty in the marketplace today. There's a lot of uncertainty with regard to performance, and it's not just uncertainty on the buyer's end. There's also uncertainty on the seller's end. And so we figured we needed to do something to try to address those points. The purpose of this forum is really to address allocation of risk as between buyers and sellers. And the CAR purchase agreement already does that in a variety of ways. It does that with contingencies. It does that with covenants, which are promises that need to be kept, and if they're not kept, there's a breach. And it does that through various seller disclosures that trigger a buyer's right to review and usually to cancel, depending on when the disclosure is given in the transaction. But there's nothing in the CAR forms that address unforeseen circumstances. There's nothing in the forms that address what many people call a force majeure clause or an act of God. So we said we need to do something because the parties just don't know what's happening in transactions these days, especially because of all of the stay-at-home or shelter-in-place orders that are really impacting transactions to quite a degree from the principal side and the real estate licensee side. This form is an optional form. Parties don't have to agree to it. If they want to come to their own settlement, they want to come to their own agreement, they want to resolve their own dispute, great. The issue, of course, that we have is that it's easier to resolve disputes if you have some kind of guidance in the law as to which way a transaction would go. And with the current events, we don't know which way they're going to go. So our view is if the parties want to fight over it, great, let them fight over it. If they don't want to fight over it, why not use this form and set up the situation where the parties can either delay performance or enter an agreement to totally cancel a transaction. So that's the purpose of this form. Let's go on to the next slide, which is also on page 1 of the form. And here's the options. The options are parties can either extend time, they can extend time to remove contingencies, or they can extend time to close escrow, or they can extend time for both. For 4A can apply and 4B can apply. As a matter of fact, if the parties are extending the time on the removal of contingencies, they really need to make sure that the time they're extending doesn't go beyond the time to close escrow. So we quite frequently, we think it's going to be possible that both 4A and 4B are going to apply. You can see that we listed the common contingencies. We defaulted to extending the contingency for 30 days, and then they would have to check a box, loan, investigation, appraisal, or write something else in. After that time, guess what? If the contingency has not been removed, either party would have the right to cancel, given the situation that we're going through. The way the form is written right now, normally in California, if a seller wanted to cancel on a buyer who had not removed contingencies, the seller would first have to issue a notice to buyer to perform. We're saying under this circumstance, the parties have already agreed, they've extended this term period. The extension of time is not necessary, but the cancellation of contract form is. Similarly, in 4B, if the parties are extending time to close escrow, maybe there's delays in getting things done, both parties want to work to each other. Same thing, if at the end of that time, performance is not possible, either party can cancel. We've said here, normally a demand to close escrow would be required, which would give somebody 3 more days. We said not in this particular circumstance. We're trying to speed up a resolution, quite honestly, of these events. In both A and B, the default is the buyer's deposit will be returned, less escrow company fees and their title company fees and costs. You can see for the extension of close of escrow, there is a option there. It's in that blue box. And it could say, oh, well, the buyer's deposit will be released to seller if allowed in the agreement. Well, why would it be allowed in an agreement? A good example would be maybe buyer removed all their contingencies already. Buyer and seller are willing to give the buyer more time in order to perform. But if a buyer does not perform and the buyer has already removed contingencies, in normal circumstance, that buyer would be in breach of contract and the seller would be entitled to damages. So again, do we know how the courts will interpret contract provisions in the current environment? Not exactly, but maybe that's what they want to agree to, because maybe that's the best resolution for everybody just to get on and move forward. So that is a possibility. 4C is mutually exclusive from 4A and B. And that's it. The parties get to this point where they say, you know what? There's just too many unknown issues right now. We think it's best for us to just mutually cancel the contract. Seller would then have the ability to move on and find another buyer. Maybe the buyer would not do anything. Maybe the buyer would move on. We don't know. But the parties are saying, our best move at this point, we don't want to extend, and we think there's so much uncertainty. Let's just have a cancellation. For all of these things, 4A, 4B, or 4C, the triggering event is now with this new form that we came out, and we call it the NUCC form, Notice of Unforeseen Coronavirus Circumstances. And that's what triggers coming into play 4A, 4B, and 4C. You see with the mutual cancellation, the parties need to attach that form with it. So let's take a look at that form, which is next in my next screen. And here's where the party who's being affected by coronavirus, COVID-19, a lot of names for it going on, that's the affected party. It could be the buyer or seller. Hereby gives the other party notice. What are they telling the other party? They're saying, I am affected, and here is how I am affected. And so we put some of the things that we found are the most likely items to be raised. So the first one is, maybe it's a loan-related issue. And look what it says there in paragraph 1A, the first checkbox. Loss of income due to one of these circumstances, but notice it goes, which prevents the buyer from qualifying for the specified loan, right? So there's two things that have to come in. The buyer cannot just say, there's a pandemic going on, so I want to cancel. I don't know what's going to happen with my loan. That's not right. The two triggering events are, it has to be due to the circumstance, and it has to prevent the buyer from qualifying for the loan. And so a good example would be loss of income. So maybe the buyer is in the restaurant industry and has been laid off, or hours have been substantially reduced, right? So the buyer could say, well, why was I laid off? Because of what's going on in the environment. And as a result of me being laid off, I no longer qualify for the loan that I otherwise would have qualified for. But you may have a buyer that does not need income. Maybe the buyer is, just relying on their assets, or maybe the buyer has investment assets and is still getting dividends or the like. So it's not the fact of the loss of a job that would necessarily cause a buyer to be unqualified for the loan. So those two events need to be there. You could see maybe you're having difficulty getting a notary out. Maybe the lender has certain delays. Shelter-in-place orders have caused a lot of issues. How do you get a home inspector out? Maybe some government inspectors aren't coming out. A mover, may not be able to come out. A pest control company may have set up a tent, but they have difficulty coming back out to take it down. All sorts of things that are there. And then personal impact, of course, if somebody has been ordered to stay at home, they're going to have difficulty moving out, for example. That could apply to a seller. A buyer may not be able to move in. A buyer may not be able to come and do a final inspection because they are hospitalized or they're ordered to stay at home. So 1A, B, and C, here's the why. This is what's going on. Paragraph 1E is there to say, what's the impact on the transaction? Well, the impact may already be stated in 1A, B, and C, so it may not be necessary. It may be a little bit less clear. For example, let's say you were in 1B, you checked home inspection. But the home inspector is now, assuming it's allowed under local law, said I could come out, but I've been delayed. I'm behind by 1 week or 2 weeks because of the previous shelter-in-place orders. So maybe that's the explanation that would go. You would check 1B. In 1B, you check that first box, home inspection. In 1E, you'd explain, here's the reason why my home inspector is now 2 weeks behind because they were forced to shelter in place for a while. Paragraph 2 is also crucial. You need something done in paragraph 1 and you need something done in paragraph 2. Paragraph 2 is the verification. So it's one thing to say how you were affected, one thing to say why you were affected. It's another thing to prove it. There's a lot of suspicion in the marketplace these days where some people just don't believe someone who's giving a reason. And this NUCC form, paragraph 2, allows you to act in good faith, let the other side know that you have a legitimate reason. Why do you have the legitimate reason? Here it is. Here's the verification. Here's a note, from my doctor that I cannot leave. Here is a note from my employer saying that I was laid off or I was furloughed or my hours were reduced. It could even be something as simple as you have school-age children and schools are closed and you need to stay home to take care of them. So that's the value. This NUCC form works hand in hand with the CVA form. You start with the CVA and then you give your reasons and your proof with the NUCC form. Once you give this NUCC form, that triggers either the extension of time or the mutual cancellation. So let's move on to some of the other new things that we came up with. A listing agreement addenda. Well, listing agents, of course, are impacted. Sellers are feeling impacted. Could they write their own addendum or amendment to a listing agreement? Of course they could, but we're trying to address some of the issues for them. Notice in that red box in that first full paragraph, it says, in consideration for the mutual benefits contained herein, seller and broker agree as follows. Because we say if there's an amendment to a listing agreement, both parties are getting something out of this. The broker and their agents are getting something out of it, as well as the seller is getting something out of it. So paragraph 1 concerns whether the seller will or will not allow prospective purchasers to come to the property. If so, okay, then what has to happen? Then the broker has to provide, first thing the broker is providing the seller with the form that goes along with this. It's the PEAD form, the Property Entry Advisory and Declaration. So where the seller says, here's what I am consenting to if somebody's going to enter my property, and the seller's making representations regarding the seller's health at the same time. So paragraph 1, we look at paragraph 1A, I've got that little red arrow pointing to it. At the very least, the seller says, if I'm going to let somebody in my property, at the very least, I want them to sign a statement. I want them to give an affirmative representation regarding their health and how they're going to conduct themselves while they're in my property. And what statement can you use? Of course, you could use that same form, PEAD form, at the same time. The seller might insist on other items that we have there in paragraphs B and C in number 1. For example, the seller may say, I just don't want everybody trouncing through my property. I only want people that I know are already financially able to purchase, and maybe through an all-cash verification, or at the very least through a pre-approval statement. And maybe the seller says, again, I don't want looky-loos. At the very least, I want people who have seen my property online. So paragraph 1 deals with prospective purchasers and what the seller needs to do. Paragraph 2 addresses anyone else that might be coming onto the property, right? It could be a seller's broker, it could be the buyer's broker, it could be buyers, it could be home inspectors, it could be stagers, it could be movers, it could really be anyone, okay? And there's a laundry list of things that the seller says, okay, I'm willing to allow these authorized people to enter my property because I want to get my property sold. And if people can't enter the property to do their jobs, then the property won't get sold. So the seller's saying that, well, look in that first red box in paragraph 2. Anyone that comes onto the property has to follow the same requirements as specified for prospective purchasers. So anyone who comes on is going to have to sign that PEAD form and agree to abide by safe practices when they're in the property. Let's scroll down and see, obviously, if you had a marketing plan, you're probably going to need to change it given everything that's going on. Paragraph 4, it's possible that with what's going on, maybe the parties are not yet in escrow. Maybe the seller and the broker say, you know, maybe we need to pause our listing for the time being. So let's put everything on hold until we get some issues cleaned up, until we figure out what's going on in the marketplace. So can the seller and the broker agree to it? Absolutely, that's what paragraph 4 is about. 4A is the default. They're going to agree to pause. You need to check with your own MLS to find out how you report that status in the MLS. The listing agreement is still in effect during the pause. Why do we confirm that in this form? The reason we confirm that in this form is because we don't want the seller to say to a broker, okay, let's take a pause, and then the seller turns around and sells the property to somebody, right? If it sells during the term of the listing, the broker is entitled to compensation. So the listing doesn't go away. It's just the marketing is on hold for a while. Now, since there's uncertainty as to how long that may be, it's very possible that 4B would be applicable, and that you'd say, you know what, I'm the broker. I was given, you know, a 6-month listing. If we're going to be on pause or on hold, you know, for 2 weeks, 4 weeks, 6 weeks, whatever, I want to add that time to the end of my listing agreement so that I have that full amount of time to try and market and sell the seller's property. And that's what 4B is about. You see, though, it does not go on indefinitely. We have a definite date there at which point it would definitely terminate. Why do we have that? Because the law requires, real estate law in California requires listing agreements to have a final date of termination. So those are your options there. The next page, and what I'm showing on the screen right now, is the scope of broker duty. And basically it says to the seller, listen, we can't guarantee that no one's going to contract coronavirus, that you're not going to contract it from somebody who comes into the property. We can't guarantee that somebody's going to wear a mask and put on gloves and not touch anything, right? We can't enforce those things, but of course we're going to ask anybody to do it. If we find out that somebody hasn't done that, we're going to let you know, and we're going to make our best efforts to prevent them from coming back to the property. There's also an indemnity and a hold harmless language in paragraph 5. There's a lot of discussion in the legal community as to whether it's appropriate to do that. Some people question whether it's enforceable. At CAR, we believe it is enforceable because this is a contractual arrangement that has mutual benefits for both seller and broker, but there are some thoughts about doing it a different way, and we're taking those into consideration. All right, so that gives me a few minutes to talk about our, oh, I forgot about the property entry advisory, and then I'll spend maybe 5 minutes on our landlord tenant forms. So what does this form do? We want the seller to sign it. We want any broker who's involved in the transaction who's going to enter the property to sign it. And we want anyone who's going to enter the property to sign it, okay? And it starts off saying that under federal and state law, real estate license activity is an essential service, so it's allowed. Now, it may not, property entry may not be allowed under local law, and it's up to you to find out what local law is in your area, okay? You have to comply with the most restrictive law. But the heart of this form is paragraph 4. It's what the parties are agreeing to. Whatever anybody who signs this form enters the property, what are they agreeing to? Okay. So, for example, 4B, you know, what's the risk, right? And 4G, we're not saying you can violate the law. A seller and an entrant cannot agree to violate the law, okay, regardless. And then 4E is the big paragraph. 4E 1 and 2, whoever enters the property agrees that he's going to protect him or herself. 4E3 is an affirmative representation that the person entering, and remember we're asking the seller to sign this also, right, is not infected, has not been exposed, at least to the best of that person's knowledge. And 5 through 8 are, here's the safe practices. Here's the way you should conduct yourself when you enter the property. Paragraph 5, I've got highlighted there in kind of a little yellow highlight. It says that the person who enters agrees to assume the risk, as well as the seller who's accepting risk and allowing other people to enter. Notice, very different from the indemnity language in the listing agreement. The PEAD is not a contractual document. It is an advisory and it is a declaration. We did not at CAR, we did not think it was appropriate to have an indemnity in this agreement, but we did want an affirmative representation that whoever is signing it is assuming the risk, because there is risk and we can't avoid that in the environment today. So really quickly, I'm going to turn it over to Alan to start answering questions. I got about 5 minutes left here. 2 brand new landlord-tenant forms.
Yeah, well, first of all, thank you, Neil, willing to share all of this information for us. And also thank you, CAR, acting so quickly to respond to put all this form in. So far, we see Neil has expanded 4 forms. And I know the first form, the coronavirus CVA, was being amended once already. So we got a question from audience saying, if the client already signed the original one, when the new amendment come out, do we need to sign again?
All right, yeah, great question. The form just came out a few weeks ago. It's already been modified. And we continue to receive comments, so it probably will be modified again in the near future. So does the new one need to be signed every time there's a modification? My answer is absolutely not. If for some reason both parties are willing to, they like the revised language, they think it addresses issues better for their purposes, they can, but it's certainly not required to. As soon as they sign that CVA form, whether it was the first one or the initial revised one, that becomes a contractual term between the parties. One side cannot unilaterally change it. You would need to have the agreement of both sides to agree to change it. It is not a requirement. People would just have to look at it, kind of, maybe they'd want to see one of the webinars that CAR puts out whenever we're making these changes, and they can decide for themselves whether it's worth it to bring it up again to get a new one signed. My best guess is in most situations, it's not going to be worth it to raise that whole issue a second time, but the parties can decide for themselves. Thanks, Alan.
Okay, I understand this is just a disclose amendment for the guideline to let agent, the buyer, seller to have some issue to follow. Can you explain to us on the real world, the real situation coming about this form to pour and come to the buyer and to the seller? You know, they should sign or should not sign, because I do have a lot of agents ask me, we already had a listing, we already starting showing, should we go back to have them all sign this new form or not? Then they will ask me, say, why if my seller doesn't want to sign, what the consequences are going to happen? My answer at this moment is, well, first of all, you have to read, understand the form, and then explain to them clearly. Of course, we cannot point the gun to force them to sign anything, but they have to know the important urgency to sign. But I do want to hear from you to explain on the legal base on these things, you know, and special in the actual market.
Yeah, absolutely, Alan. And it sounds like you're talking about the form that I have up on the screen right now, the Property Entry Advisory and Declaration. And I think this form should always be used. Even if the seller and the listing broker do not sign that listing addendum, this form is very protective for a listing broker, right? Even if there's no addendum, even if the addendum is not used, this form is protective because, listen, the listing broker and the licensees need to understand that there is risk to them as well. There's risk to them in allowing parties and third parties into the property to do what needs to be done in order to complete a sale. And while I think it is unlikely that in the event somebody contracts COVID-19, I think it's pretty unlikely that one would be able to trace that back to one of the activities of showing the property, of doing the inspection, right, of making the repairs. We don't know that. And we have such a litigious state here in California. Why would someone want to take that risk? So my view is, particularly if you have a sale, and even before a sale, there's parties who enter the property for staging, etc. To me, I strongly advise listing brokers to insist upon the use of this new form PEAD. I think it's very protective. Again, by itself, it's not an indemnity. It's not a hold harmless agreement, but it sets the stage. It lets everybody know, here are the risks, and here are the guidelines we expect anybody coming into the property to follow. And in that sense, I think it's very helpful to sellers and most helpful to real estate licensees. Back to you, Alan.
Great. We got a couple audience questions. First one is come from any guidance in appropriate language used by agent in the field of the following impact on certain performance, like NUCC. Do we have any guidance to instruct the proper language for agent to use to fill up that one?
In terms of providing the proof, Alan, or something else?
On the NUCC form?
Right. But what kind of language in terms of what to do to prove that one of those events happened?
Impact on the performance.
Yeah. Well, for the NUCC, to me,
I believe it's on the E, 1E.
Yeah, I'm going to get that back up. There we go.
Okay.
There we go. So, no, we don't have any suggested language. I think it's going to be transactionally specific. Like I say, in many cases, if you have 1A, 1B, or 1C, it's probably not even necessary, okay? So what's going to be in 1E? To me, it's just, I would do some simple explanation as to how the item in 1A, B, or C is impacting you. So, for example, notary delay, right? A seller needs to get the deed notarized in order to close the transaction. So just checking notary delay does not tell you whether the delay is going to be for 1 day or 1 week or 1 month. So I would add some kind of point of clarification. There's 2.5 lines, 3.5 lines there. There's plenty of room, I think, to write some kind of explanation. And to me, that's it. It's just to fill in the details that are missing in 1A, B, or C. Or if you write, of course, if you write something in D, if you write something in D, you might as well just write it all there. Is that helpful, Alan?
Yes.
Okay, great.
Yeah, that's good. On the same form, that's a question. Say, this form is like a additional for the contingent remove, but with specified on only the coronavirus. But seems look like it's open end, no definite time specified on this. So this one going to be if will be part of the agreement, then it's like you have open end on the contingent, because we don't know when the coronavirus is going to end.
Yeah, I don't see it that same way, Alan. I don't think that this form creates an open-ended contingency, because it all ties back to that form CVA. And that form CVA, the default time is a 30-day extension for whatever the contingency is, or the default time is 30 days to extend the close of escrow, right? All the NUCC form does is it triggers when you start that extension, when that extension first comes into play. So The contract is just going about its business as it ordinarily would. And the extension does not happen until and unless the NUCC form comes into play. So let's say, for example, the parties are entering into contract. They use the coronavirus addendum from CVA as an addendum to their contract. They're entering into contract right now. They say, we're just not certain what's going to happen. We have our default 17-day contingency period. But because we're not sure what's going to happen in the environment, rules are changing all the time, let's make this an addendum to the contract so that if something comes up, we know, we feel secure that we're going to be able to enter into an extension. Well, again, the default for investigation contingency is 21 days, appraisal contingency, investigation is 17 days, appraisal is 17 days, the loan contingency default is 21 days. Well, the seller, during the course of a normal escrow, can give a buyer a notice to perform, and the buyer doesn't perform. The seller has the ability to cancel if the buyer does not remove that contingency. So let's just deal with the investigation contingency, 17 days.
Okay.
So 17 days, the seller can give the buyer's not removed the contingencies. The seller can give a buyer a notice to perform. The buyer has 2 days. If the buyer doesn't do it, the seller has the right to cancel. If the buyer never triggered the extension of time with the NUCC, guess what? That contingency can be removed. It will not be reinstated just because on day 20 or on day 25, the buyer now issues the NUCC. There has to be a contingency to extend. If the seller canceled or if the buyer removed contingencies on day 17, there's nothing to extend at that point in time, okay? So we treat the transaction as a regular transaction unless either the buyer or seller brings in the NUCC form before the times are up in order to buy more time. That's the issue. The NUCC's form may never come into play in a transaction. I'll give you an example, Ellen. I had a neighbor who closed escrow a week ago. No extension, nothing. Their transaction went as if there was no coronavirus pandemic going on. Nobody extended any times. It just worked as a normal transaction. The 4A, 4B only come into play if the NUCC is brought into the transaction before the contingency is removed or before the close of escrow date. Okay?
Okay, so yeah, I agree with you. I saw some escrow closed during the last week, 10 days. People still by email the closing statement, mail the check, all this.
It's still possible, yeah.
Yeah, any worry about, just during the time we didn't have this form signed, but the last few days on the escrow, they do have people went in the house to look in. I know that a lot of house on the escrow, the agent leave the lockbox there because the convenient for the buyer going to do the inspection or final walkthrough. But then unfortunately, some agent want to show a compare, or they even know this is in escrow, but they want to show in comparable for their new showing the property. They still take the client to go into the house use the lockbox to see this house in the escrow house. And then unfortunately this one, if happen, they contempt, and then going to have anything happen after the close escrow, and new buyer may consider to sue, or should we warning our agent, even they ready to close or going to be closed, and we still need them to sign this disclosure to warning the seller or the other agent to.
Right, and so that you're talking about the form we talked about a little bit earlier, the property entry form.
Yes.
And remember, my recommendation was that this should be used all the time now. Can I require it? No, but I think it's to me, it's strongly recommended that be used. If there's first of all, when you say there's a lockbox, you have to make sure, of course, that that complies with local law. There's a lot of local laws that are restricting entry into the property for showings. For example, Los Angeles just changed their law. Not only locally in Los Angeles can you not have an open house, you cannot have showings at all in Los Angeles. At the very least, prior to a contract being entered into. So you need to make sure, of course, that you're in compliance with local law. If the seller says, you know what, I want to make sure that anybody who comes onto the property, signs one of these forms, because it is advising best practices, then I would think at the bare minimum, you would need to put something in the MLS advising that prior to any showings with the use of a lockbox, that the brokerage company that's bringing somebody into the property has the buyer sign a form and send it to the listing brokerage. Some kind of notice in the remarks, I would say at the bare minimum in the MLS. And it might even be necessary to say, we're going to remove the lockbox so that we'll only do showings by appointment. And that way we can assure that the form gets signed.
I saw a lot of listing agents starting to put this form into the attachment on the MLS listing they had. So by looking at MLS, they have to download this attachment disclosure form to sign and entry form to sign and send it to the listing agent. Then listing agent will give the lockbox CBS code, so they can really tracking down all these people coming. And one of the agent in the LA area was saying like, if I have 3 showing today, and then how do I know which one really happened, had this coronavirus positive, and then effect to all 3? Do I responsible to notify all these people?
So are you saying somebody knows that they had contracted the virus, or they're just not sure?
Either because I had a notify this one from the local agency. Their company's agent went to do the open house, and then the neighbor report to the police, and they come in to shut down the open house. And they had an argument. They say, "Oh, how do I know you have so many people coming? One of this was being contaminated. Then are you going to notify everybody?" And they asked me the question. I don't think I have this, but I just mentioned to them, say as agent, our responsible ability is to disclose. And we, unless they notify you by the authority, you're not supposed to just bring the room and say, oh, so-and-so cough a lot, and maybe they should just get this disclosure signed every single person coming to the open house.
Right. So I agree with you, Alan. I think a real estate broker's duty is to disclose what they know. I don't think it's necessary to disclose that somebody who came to the house was coughing. And indeed, you may not even be present. So you may not even know what the person was doing. You get the form signed. I think that it's basically just common courtesy that if somebody finds out that they have been infected, that they should notify their licensee. And then the licensee can notify other people who have entered the property where they have an affirmative notice, right? An affirmative notice. They're affirmatively aware that somebody was infected. But prior to that, I don't think there's any other obligation.
All right, thanks. The one more question here is say, will there even be a required disclosure that disclose that a known testing positive coronavirus 19 tenant or previous owner live in the home? How about a known neighborhood that live with in the building or the next unit.
Okay, so CAR does not have a form like that. I have to say we have received a form which is a notice of infection, basically for maybe it's a multi-tenant building, to notify other tenants that one tenant has affirmatively disclosed to the owner or the property manager that the tenant has been infected, okay, or tested positive for COVID-19. Or in the case of a property that's being sold, where the owner has made an affirmative disclosure to the broker that there would be some kind of disclosure that would be made to any property entrant. And so far, we do not have a form like that. It's something that is under consideration. And right now, we're kind of just gauging the situation to see whether our members believe there is enough demand and reason to have that form. Again, to me, I think for a seller, I think you're dealing with members of the public that you don't know. I think common courtesy would dictate that somebody should make the disclosure in all fairness. And so that when somebody is assuming the risk, they know what risk they're assuming, right? For a property owner or property manager, that person has a duty to all tenants in the building, at very least to make them aware. Of course, making other tenants aware of one tenant's condition, you need to have the consent of that tenant initially, of course. And then you have to make sure that there's no unlawful discrimination practiced against that tenant. But is it a good idea to make some kind of affirmative disclosure? Yes. We just have not prepared a document that would allow you to do that with a pre-printed form at this time.
Okay, the continual discussion, that's another one, say, regarding the disclose of knowing test positive, even without a form, does need to amend including to the TDS or AVID?
Great, so where would you make that kind of disclosure that there's been somebody who has tested positive that's gone through? Would you do that on the TDS or the AVID? I actually do not think that's the right place to do it. Those are really property-specific forms, and this is not necessarily a property-specific disclosure. It's a disclosure relating to an individual. The individual may be, living on the property, but it's not really a property issue that's being addressed. And to me, that's the focus of the TDS, the SPQ, and the agent's visual inspection disclosure, the AVID. So I would just do it on some type of separate document.
So there's another question, say, please go back to the NUCC form. All this form available now to download? Thanks.
Yeah, great. So this form, in fact, all 4 forms that I've talked about already are in 2 locations. They're all on zip form, and that, of course, is the easiest way to get these forms. And you already mentioned, Alan, that we've changed the CVA form once. And I mentioned that we're likely to be modifying these forms going forward, because now that they're out in the field, we're getting so many comments on them about what's working and what's not working and what would be a better approach and the like. So in my view, there's 2 ways. I think the best way to get it is always through zip form, because zip form will always have the most up-to-date version, no matter what. The other location is in the legal documents page in the risk management section on car.org. And on that page, we have PDF versions. So they're not fillable, right? They're PDF versions of all 4 of these forms. We do update them, right? But it's a PDF version. It's not coming through zip necessarily. right? And so it's possible that somebody might have printed out an earlier PDF version and is just using a copy of that. So that's why my recommendation is always to use the zip version, because you know it's always going to be the most current version. Something we're going to be doing differently, and actually this is a great example. If you look on the screen and right below the title, it says CAR form NUCC, and it says 3 for March 20, you know, the year 2020. And that's the system that we always use to identify when our forms were released. For these coronavirus forms, we're actually going to start putting an actual date. So it will say maybe the tenancy forms that I didn't get to will actually have the date. I think it's probably going to say it's like 4/9/20 as opposed to just April 20, so that people can know, because if we had the form out on April 1st and we changed it on the 9th, it'll be difficult if you just look at that month and year. So going forward, we're going to be more specific with the dates. But again, I think you're always safe by using the zip form version. Thank you, Alan.
Okay, we still have 10 minutes to go for, and this question here is could you go over the new tenant form?
And I will do so really quickly, just to let you know what they are and what to expect. Those forms are going to be released tomorrow on zip form, and they actually already are posted on the car.org site right now. So the first one is a letter. That's the one I have up on your screen, NTAP. And the purpose of this letter is to start a dialogue between a property owner or a property manager and the tenant. And matter of fact, look at that first line. Listen, I understand a lot of tenants are in a difficult position right now, but so are a lot of property owners. And if you look at that first red box there I have in the first paragraph, one result of these orders is the loss of income for many of us. It's not just a loss of income for tenants, the loss of income for a lot of property owners as well. And so we're trying to set the stage. Let's see if we can work something out. That's the whole point of this letter, okay? And the letter goes on to say, while we may defer rent or abate rent, it's not going to be forgiven, okay? And please give us a call. Let's talk this out. Let's see if we can figure something out. The next form, again, available tomorrow in zip form, available in a PDF version on the car.org website. This is the actual agreement. So the landlord and tenant, they've talked to each other, said, you know, it looks like we're having some difficulty here. The tenant says, I cannot pay the full rent, but maybe I could pay partial rent. Maybe I could pay half the rent. So this form says, first, oh, there's been a request for a delay or a deferment, okay? Paragraph 2, here's the reasons why, very explicit reasons why: unable to work, experience a layoff, have to care for a child, etc. Okay. Here's the proof that's either going to be attached or it's going to be provided shortly. Okay. And we list the kinds of things that would be acceptable as proof. And you can see that in paragraph 3C. Okay. Termination notices, payroll checks, pay stubs, and the like. And then we get to the heart of this agreement, which is paragraph 4 and 5. In paragraph 4 and 5, identify by month. Here's the rent that's due. Here's the rent that's going to be paid, if any of it, right? And here's the rent that's going to be delayed. And you identify that month by month. And paragraph 5 is, here's the repayment plan. Now, I have to tell you, 5A says all at once starting on June 1st. That's not very realistic, okay? But we just had to have a default in there to have something. But honestly, somebody who's not able to pay all their full rent for April and May, probably not going to be able to pay all of that back rent on June 1st, but we needed to have a default and started with something. So I suspect if anyone's going to do 5A, they're probably going to be filling in a different date. But 5B is when you say, let's spread this out over several months. And spreading it out over several months is very consistent with a lot of the local ordinances that have passed that allow tenants various amounts of time in order to pay back the back rent. So I think that's my summary. I don't want to get too much into it because I know we're coming up near our 1 hour time frame.
A couple last comment. As Neil, as you know, the AREA is a nationwide organization, and this show not only just California agent to watch it. We believe whole across the country, a lot of AREA's members looking, even the public outside AREA member
Yes.
agent also looking this one. So I think this CAR, this form were leading become a regular standard guideline to the real estate agent across the country, or they can, other states, they can use this one as a sample to disclose to their people.
Right. So the answer is basically yes. Well, first of all, we think the form itself is very good as a template that might be used outside of California. And so I'll mention two things. One, in ZIP, not CAR, but REBS actually has a national forms library in ZIP. And these forms that we've created, there's another attorney on staff that's going through these forms and taking out anything that's California specific so that they are being posted to the national ZIP library. So that's one thing. The second thing may not be available for individuals. It is something that I belong to. It's a listserv for state association attorneys that's sponsored by NAR. And so anybody who's in another state may want to, and all of these forms that we've created are being supplied to NAR, and we're allowing them to post these forms on their listserv. But every member outside of California doesn't have access to that listserv. It's for state association attorneys. So if you like these, and I think they're really good, and I think particularly this rent delay agreement can be used really anywhere, talk to your state association attorney if they haven't created one yet, and say, go on to that listserv, find the CAR forms that were posted, and we're giving permission. The CAR CEO, Joel Singer, has given permission for these things to be posted and for people to use them as they like, as a template, and maybe adjust them as necessary for their own state. Thanks.
Great.
For listening, Alan.
Great, thank you very much. One more question for the California member, California agent. We know the CAR have a legal hotline. Of course, this period of time must be overloaded for you guys. And if they do have this question or not clear by this presentation, and they want additional information or something happen, can they still call the legal hotline for CAR legal hotline for ask this kind of question?
Yeah, great. I'm glad you asked it, Alan. The CAR legal hotline has been open this entire period. Our staff has been working at home, I think, for 3 weeks now, but the legal hotline never closed. It was always open. There's some days where we've just been so inundated, there's been long wait times, but not every day, quite honestly. Okay, so give it a chance. I'll read the number right here. It's 213-739-8282. The hotline is open for business. All of our attorneys are working. We're just working from home instead of in an office, that's all.
All right, thank you very much, Neil. Really glad to see you. We know each other for so long, and thank you for all the information. And we definitely know we're going to ask you to come back one of these days to update us and to know all this new question, no tough question or some question you may be thinking, you want won't be asked, but believe me, people ask all kind of questions. So nice to chat with you. Now our time is end, and thank you, John Wang. Thank you, Area National, to put these things together, and hope you like it. Goodbye.
Thank you very much. My pleasure to be part of it.